And thank you everyone for joining. We talk about hidden exposure, this legal risk that's kind of buried inside these time capsules, these modern websites that have gone through so much change over time. And now with regulations getting much sharper and a little more pointed, um, we're looking at what we may have caused over time as issues, exposure issues. I'm joined here by the expert Abhi Mukundan. Abhi, would you please introduce yourself?
Absolutely. Thanks, Nick. My name is Abhi Mukundan. I'm based out of Dallas, Texas. Been in the privacy space for about 8 years now. Stumbled into it as part of an implementation I was doing for a retailer. And that's when CCPA had gone live in the US. GDPR was also functional. And that's when I got to know what privacy was. Started working very closely with marketing systems, customer management systems, customer service. Realized all the different pockets in which data is hidden, mostly personal information. My background before that was large program implementation, so I understood how data flowed within the organization, all the way from for a retailer, for a financial organization, for a manufacturing organization. That gave me the insight about pockets of data lying in different places and integrations between systems. So that took me down the path of looking into privacy. I took my certifications with IAPP as well, and then got us down into helping customers. Privacy is not something that most customers are ready to handle with right now. They are evolving, but it's almost like InfoSec was 20 years ago. It's now evolving and it's getting much better. But that said, they do still need that expertise. It's hard to hire for such expertise, and that's where we step in and we assist our customers as well.
Amazing. My name is Nick Rajpal. I'm a veteran marketer. I've helped run a e-commerce retailer focused marketing agency from 6 employees until over 400. And I recently worked with Abhi to help solve some problems where I was CMO at a fashion retailer and now working together on some webinars. So, Abhi, can you walk us through maybe kind of some of the more recent, more notable, more public cases that people have been dealing with recently?
Absolutely. I think the first one was the most prominent one was Sephora. It happened a little while ago, and this was one of the first more noticeable settlements or litigation that took place by the CPPA. They had basically conducted, they were sweeping for looking for retailers. That's when the enforcement agency had just gone live, and they stumbled upon Sephora. I think at that point, one of the first main litigations to take place under that particular law, which is why maybe wasn't taken as seriously. The tools were in place, but they were not being followed. They were not being implemented correctly. That resulted in basically Sephora getting fined. It went back and forth. It was a much larger fine. It got settled, but they were used as the poster child for things that can go wrong. And that was the case for website, consent related, privacy rights fulfillment related. Also, their GPC controls are not being honored. So this became quite a back and forth with the CPPA and Sephora as well. But this has become a landmark case. A lot of customers then realize that they do need to have a do not sell or share my personal information. They do need to stick to the timelines. So all of this became a foundational case for folks to refer to. Honda was the next big one. Again, not necessarily in terms of timeline, but with respect to visibility. Same thing. They had a tool. I believe they had OneTrust at that point. And the statement that was issued was basically said that, hey, the tool itself is not the problem. It has not been configured properly. And some of the things noticed was whenever an authorized agent was putting in a request, it was not being fulfilled properly, or they were asking for multiple rounds of back and forth. It made it hard for somebody to put in a request on behalf of somebody else. In addition to that, they were sharing information. They were selling that information, and that was not disclosed. Even that sale of information was not being done with the right contracts in place. So that became an issue as well. And all of this brought up, and it resulted in a CCPA settlement for Honda as well.
Amazing. And all these are kind of public and available on different government websites as well. Um, some of them are ranging much higher, and but some just kind of hit the sweet spot of fear for fashion brands, for example, 300,000 plus.
Yep. Yeah, exactly. And Todd Snyder was along the lines of what happened with Sephora. Same thing, not fulfilling the requests within a 40-day timeline, not communicating with the data subjects, asking for more information that was required. This was another landmark case that allowed CPPA to send the message that, hey guys, you need to make it easy for people to opt out. And that's a clear thing that came out of this one as well, along with Sephora. Do not ask for any information. There's no need for communication. But when somebody puts in an opt-out request, it should be quick, it should be seamless, and it should be done immediately. DoorDash was another one that's more recent, but the same similar patterns where they were, with respect to not providing proper notice and not opting out. This was also a very similar case along with CCPA and Calopa that basically resulted in a settlement for DoorDash. Forbes more recent, $10 million, and this is still in process. They've still not settled the whole thing, but they are heading towards a fairly, and this could be a class action suit. So there could be people who have associated with the organization that will end up gaining some settlement from that individuals as well. So this is a pretty obvious one that has also resulted in not providing the proper notice when the data was being collected and shared, and not collecting consent for the same as well. So this is also a very critical settlement that happened or is in the process of being finalized.
This is going to start putting all these problems on the map for businesses that have kind of not been paying attention as well.
Absolutely. I
Aside
think
like
a lot
this.
of these things, Nick, in addition to the standard CIPA challenges, right? So you have CIPA on one side, you have CCPA on the other. So California is becoming a hub for all this litigation. So we are actually working very closely with our customers to tell them, hey, you need to look at a strict opt-in consent model for California. And of course, retailers in particular are very, very skeptical about that approach, and are also concerned that that might result in a lack of visibility of usage, because a lot of the tracking that happens not for ad delivery, it happens for just site usage. It is trying to stitch that person's information between site to site. So they're able to then identify all the different locations this person has been, with the intent to be able to serve up more personalized ads, to serve up more enough triggers to allow them to be able to then click on add to cart and then buy. But all of this is happening behind the scenes. It's not being communicated to the consumer. They're not being given an option to be able to opt out. And we'll talk more about the dark patterns that are involved as well. But then that's something that all these cases are now compounding the need for you to take a good look at privacy and also figure out alternate means by which you need to be able to get to that objective. Again, as you can see, some of these things that have resulted in the violations, management of marketing pixels has been back and forth throughout. You use different tag managers, you call them directly from the CMS. Depending on the platform you're using, that platform provides plugins or apps. Like Shopify has a whole bunch of apps that you can fulfill several functionalities with, including product recommendations. But those apps, along with the chatbots that are out there, migrations of platforms, many times customers move from one particular CMS to another one, like onto Shopify or away from Shopify. But then they still have certain pieces of the site that are live, and they're still hanging on to those pieces, and that is accessible. And that is not being looked under because they're just sitting there in the background. But then that's exposure as well. There are tracking pixels sitting on those pages. Agencies change. We've seen this happen a lot, especially with small to medium businesses. They basically have one agency for a while, and then they realize that, okay, we are getting better results, or somebody recommends another agency. They flip agencies. The remnants of what the previous agency has done, the new agency does not want to tap into that, so that just stays there. And then this agency starts creating their own tags, and they basically say, we don't know what that is, but we know what this is. But the old agency's work is then left behind. Similar, you'll see the same extension within employees. I don't know what was happening. I don't know what that person was thinking when they put it in there, but that person is no longer here. And sometimes, and this gets me every time, they don't even have access to some of these containers, or even to the AdWords or the GA4 containers. They say that that person had the login. It is on that person's login. They have left. We don't have it anymore, but that tag is still sitting and it's active on the website. So these are some obvious problems. As you can see, individually, they're not a problem, but when you put them all together, it just blows up the risk.
I think any marketer who's been marketing for at least 5 years digitally has probably faced every single one of those things as well. It's just the most common things. And you know there's problems bubbling up because of these actions, but you have no idea what to do about it. And at the moment, it doesn't seem important.
Yep, I agree. A good article from OneTrust here regarding CIPA exposure and they call it out here as well. The consent banner that allows behavior to take place. They're talking about an opt-in behavior. It allows that pixel to be able to run without getting consent. So this aspect of CIPA cases, I mean, there were over 800 cases last year. It's only growing this year. That exposure in terms of dollar amount is growing, and a lot of SMBs don't have the leg room to be able to go back and forth and handle that, and they just say, you know what, let's just get the settlement done and let's move on. But that's hitting your bottom line. That's also making you wonder if is it going to happen again, because ambulance chasers are out there. Once your name is out there, you pretty much keep getting hammered and hit multiple times after that. I think from an exposure standpoint, this boils down to, yes, collecting, sharing, infrastructure, and governance. And we talked about it briefly. We talked most of the time when they're adding a new ad tech vendor, they don't realize the information that is being shared as part of that interaction. They could be sharing IP address, they could be sharing order information, they could be sharing zip code information, geolocation, whether it's precise or not. All these aspects impact collection. And if that information is not being captured and disclosed in your privacy notice, that's when regulators will come after you. And this happens quite a bit. And for you to know what you're collecting, you need to actually do an inventory of every vendor and what is their interaction with those vendors, what data elements are actually being shared. And this is not just on your website, this is also through your business processes. So think about your payroll vendors, your background check vendors. You're sharing information with them about your consumers or your applicants or your employees. That needs to be clearly made available in either the privacy notice for the consumer on the website or the privacy notice for the employees within the organization. This is causing a challenge. Same thing, with collection comes sharing. You're collecting to be able to process, and then eventually you end up sharing it with others. Infrastructure, we discussed this briefly as well. This infrastructure piece has to do with old infrastructure being left behind and not being completely decommissioned. So you sunset a system, but you don't decommission it completely. You basically don't unplug it, and then it's running. Governance, of course, and we see this a lot between marketing, legal, and we'll talk more about this, but the ownership of who's going to bell the cat, so to speak, is what is always left open. So when it comes to collection, Nick, you probably have seen this being a CMO yourself. The idea is to be able to get as much information as possible. I want to know how long this person was on the website, how many people visited, from where did they visit, what is that information that I'm getting as far as how do I improve this page? How do I make sure there is more stickability? I mean, I think you can speak about it from a CMO standpoint, Nick, in terms of what does a marketer look for?
This is the marketer's dilemma, and we know that we are creating chaos, but we can't help ourselves. Someone says, "I wonder what XYZ is happening," but we just have to figure it out. So we create any way to track from sometimes multiple sources that are overlapping, or create some kind of system that allows us more access. But we're always trying to collect more and answer big questions. And then you move on to the next big question. Oh, we figured out what was going on in terms of our cart completion issues. So let's just leave Hotjar on there. It's at some point we're gonna need it again. And that type of thing goes unseen for a long, long period of time. And of course, Hotjar is the type of technology that is at the center of quite a bit of California consent issues. Chatbots, you might think you're doing everything right? You're just trying to help your customer service out. They say they're overloaded. You're trying to figure out, is there a way for me to get more cross sells and get my conversion rate up? So the chatbot is a smart idea. But the vendors taking those transcripts, and you didn't realize it. You didn't read that one line in your paperwork, and all of a sudden you're actually sharing data. You're collecting data. You're
Yep.
sharing potentially sensitive data, order data, but now it's going off to the vendor. I think the pixel creep is it's like one of the more like common cases. Your nest of data that you thought was a good idea. It gets you out of tough situations with your COO, your CMO, your head of merch. You can plan better. Any question that comes, you have so many sources of data, even if sometimes they don't communicate the same numbers, but you know how it works.
Yeah.
But you're not a consent manager. You may not be the right person to have done all that without other people knowing.
Right. And I think one point to add on the chatbot also is many people say that's a functional, they classify that as a functional cookie. But the problem with the chatbot is, like you rightly mentioned, they're keeping track of which page you are on when you actually clicked on the icon. And even before you click on the icon to say, I want to chat, even that's not intent for you to be able to share information. The right way to do it is to wait for that click to happen and then ask for consent, unless, of course, consent has already been received. So if somebody has targeting and performance turned off, like in a GPC situation when they have their GPC control turned on, that chatbot should only trigger its scripts when it's clicked and it's been said that, hey, do we have your permission or consent to be able to track this conversation and use it for our purposes? Whatever legal language is needed there, that should be given before that tracking happens. And that doesn't happen. Every chatbot off the bat is constantly tracking you. And then you'll also see it automatically pop up all of a sudden. Hey, is there something I can do to help? All that is causing a problem with respect to implied consent, which is actually incorrect and can get you into some hot water.
Yeah, so there's this, I mean, the big question here is, what have you actually installed? Do you still need it? Who actually owns it? And has it ever gone through the consent process and is it really consent ready? Um, this one is tough because everyone's always asking you for more information that you know you're sitting on as a marketer or someone who has access to any one of the data platforms that you're sitting on. But that's that kind of sharing can sometimes get out of control. One of the most interesting ones is one that you brought to my attention, Abhi, that some people create middleware just to connect, like string together, stitch together data that is coming from one place and going to another. That person leaves. All of a sudden, you have middleware running and sharing data. No one knows even how it was created.
Yep. And I think another thing that's coming up here is server-side tagging is a new process. Elevar is a vendor that works in that space, where they're thinking that if server-side tagging is nothing but instead of collecting everything on client side, you're actually sending it to a first-party server of the customer itself, and then they are choosing to share it with Facebook, with LinkedIn, or with Google Analytics or Google Ads, whatever that might be. That is good for better data enrichment, but it's not necessarily compliant as far as consent is concerned. So. And changing hands, like you said, is also a critical part. Whether agencies are involved, whether consultants are coming in for a short term, or even for a long term, or employees are leaving, there is no ownership for what has already been done. And of course, the whole concept of capturing data from your CRM, putting it in a SharePoint, leaving it there, those are other data security breaches that can happen. But of course, these things are par for the course in most organizations.
Yeah, absolutely. And so essentially part of the role of governance, figuring out whether consent is being violated, is who's getting data from where, do they actually need it? And does it conform to correct regulations? But a lot of it is really just rolling it back. We didn't need
Again,
this anymore.
absolutely. And I think the part here also is, if you notice, one of the litigations was about the fact that Honda did not have the right contracts in place before they shared that information. So there was no accountability between Honda and the vendor with respect to what information was being shared, why was it being shared, who's responsible. Nothing was done and data was just shared. So once that data sharing has already been in place, that already becomes a problem for you from a regulator standpoint. If you don't have a clear paper trail in terms of this is whose vendor, whose information we have, this is why we are sharing it, and these are the contracts that are governing that sharing, then you're just asking for trouble, which is exactly what happened for Honda as well.
Well, this is one that I'm very, very familiar with. As a marketer, this is just, the moment you are given ownership of a website, whether as an agency, with maybe 400 or 500 clients at a time, but over time, over the 20 years, 16 years that I was there, probably had 1,500, 2,000 clients coming at different parts of their, so agency, or you get a new job and you're given a website. You don't know what's been there. That's part of the job of an SEO, which I've been an SEO for most of my career, is using systems to find all this like hidden, missed, forgotten stuff that is out there.
Yep.
So, um, I'm happy to talk about some of these that I've experienced. There's migrations, whether you're going from like the old school platforms, Yahoo, Magento, even if you're going Magento, a new version of Magento, but then obviously everyone has shifted to BigCommerce and Shopify over time. They left parts of their website behind. They left microsites behind. There was a period of time in the early 2000s where everyone thought you should have a microsite because it was before exact match domain update from Google. So having key terms in your domain was helpful. So they created multiples of variations of the pre-Wayfair model, if you will, where you have hundreds of websites. All of that, orphaned pages, old products, all of that could potentially be part of a system that is not getting the updates that you do to your website. So they've been untouched. They are not in compliance at all. Holiday microsite is such a common case here. 75% of SMBs say they rely on holiday sales just to meet their annual goals. So they create something splashy. You got your
Yep.
gift section, gifts for her, gifts for him. You got different skins. You got versions from 2005 still somewhere. Maybe it didn't migrate well. You never thought about it. Um, but those sections maybe even been created using landing page editors that weren't even native to your templates. So now you didn't even use the right headers and footers and code in there. And of course, unmigrated sections, which I was speaking about earlier, you can go to um, pretty much any website that is supposed to have a folder taxonomy where it's website slash collections slash or products slash, and you're looking at a Shopify website or a BigCommerce website. All of a sudden, you're getting nomenclature that is showing up in Google's index that has
Yep.
nothing to do with your current site, which means those pages still exist. They were not migrated over. Someone thought they didn't need to be part of the consolidated migration, and then they forgot while they were dealing with some post-migration issue, they forgot to go back to the old sections.
Yep. I think, and like you mentioned, Nick, this happens more often than not. Every site has evolved over a period of time. So most of these migrations will leave some links, some segments left behind, and those are the ones that have all the, and they might not even be in your top 100 URLs. It might be just something that's waiting to spring up. But then, yeah, that is
Yep.
also a challenge.
Yep. So this is just taking stock of old efforts, what's still around, how do you even find it? Again, using tools like SEMrush and isolating what you know you're supposed to have today versus what else is popping up in crawlers in Google's index. That's a good way of starting to identify and single out what you might need to take a second look at or just remove entirely.
Correct.
This is the one that I think every organization, I know at the last organization I was at, if you had every single person in the company in a room and you said, which one of you actually owns consent, you could get a lot of hands in the air for a lot of things. Who owns marketing? I do. IT owns infrastructure. Operations got that customer data, but all of those intersect with consent and not a single choke point, not a single person who says, that's my job. That's why I'm always in your face about marketing data because I own consent and it buck stops at me. So I'll be that so that's where you come in first and foremost, right? For a lot of organizations.
Absolutely, yeah. And this is where I think it starts with legal. It starts with the legal exposure that is possible, and then legal naturally moves towards either the marketing or the customer management teams, either one of the two, and they ask for assistance with that. Technology, of course, is underlying because your IT organization is driving the infrastructure upon which the business functions. But that choke point is a very clear problem because legal will say, yes, I own consent. I need to make sure that the company is protected from a legal standpoint, but I don't know all the different places consent is being tracked. And an example is email consent is sitting with another vendor. You have SMS consent sitting with a different vendor. You have direct mail or snail mail consent sitting in a very different system. Then you have the do not call list, which retailers have to maintain. That do not call list is sitting in some DB2 mainframe system. So now you have 4 or 5 different systems that have different images of the same person. And here's the kicker, there isn't a unique identifier between all of them. The do not call system works off of phone numbers. The email system uses the emails. The SMS works off of the phone numbers as well. But then when you're trying to do a match, you can't necessarily do a match based on these identifiers. You need something more than that. You need first name, last name. You need then your physical snail mail is based on the address. When you get into addresses, you get into householding. Householding is nothing but all the people that are living in that particular household linked to that address. They become one single record, and that's called householding. So there are several reasons why this can get pretty complicated pretty fast, but it starts with somebody in legal or compliance saying, it's my problem. I'm going to hold the fort and make sure I bring all these people together. Then the process starts off for having a master data management system or a system which allows you to be able to consolidate and identify. And it also helps long term because then it allows you to have a 360-degree view of that customer across all these consent platforms because each of these consent platforms also have different data points. How many orders were placed, when this order was placed, what was placed, where did they ship it to? So that then you begin to create a 360-degree view of the customer.
Yeah, they're fantastic. And obviously, we have some other cases here. We have former employee has access. The consent manager, the person who's in charge of that, has to know who has access to everything, API keys that are still active. But these are checklists that you need to maintain at all times. But obviously, the catalog of third-party inventory it's a rigorous, it's a process that even if you're trying to do it, you don't really know all your categorizations. Like you have to learn this. It's
Yep.
very not an easy thing to
Yeah.
do.
And part of the problem here also, Nick, is the fact that depending on the size of the organization, your vendor onboarding process is not streamlined. So in teams that have contract management teams or procurement teams, not every single vendor goes through them. Most of the time, business has a threshold of dollar amounts spent under which they can directly have a relationship with the vendor. If that threshold exceeds a certain number, some organizations will say we'll have to go through an RFP process, and then that's a very formal process, which is very well gated and monitored. But if a vendor is saying, "Hey, I want a quick and dirty solution. We are launching this campaign. We are just piloting this. This is going to be a proof of concept. We want to get going very quickly, and it's going to cost us less than $10,000." They go ahead and start that relationship, and next thing you know, data is flowing from customers. They're sitting on the website and they say, no, this is only going to be part of A/B testing, so it's going to be 5% of our customer traffic, but that 5% eventually matters as far as the data sharing is concerned.
These are incredible. I mean, like easy to know cases. Anyone who's been in the marketing side or e-commerce side, every one of these things has popped up at one point or another. Um, and this is the final of four ways. This is, when it comes to consent, who on your team is ready
Yep.
to handle it all. And I've seen the impact of having you all become part of the organization and start to pull that expertise
And
together
that's
within you.
where you're right. I mean, that's where we can herd the cats, so to speak, towards a, but somebody in the organization has to put their hand up and say, we need help. and I will try and identify the right person. And that's where the ownership stays with the company. But we can then take the reins from that point on. But somebody has to bring us in. Yep.
And ownership and competency are kind of the two things that are hard to figure out. You need someone internal, but you also need someone who's gone through all this. But the how easy it is to have the problem that you get a lawsuit around because it was outside of your wheelhouse.
Yep.
That's where all these cases that we covered were, people like major businesses attempting to do it right, but something was outside of their wheelhouse in terms of understanding.
True. I think one thing that we can definitely help with is very quickly, and we do this quite a bit, is to do a very quick one to do a business audit. We can look at what's happening, identify areas where pre-consent cookies are being dropped, scripts are being fired. What does your banner look like if you have one? Is it following a dark pattern, which is not providing a reject all button, just telling them, hey, we dropped cookies, and that's it. GCM implementation can also be looked at. Identifying hard-coded scripts takes a little more work, but that's why we can actually look at the code that's on the site. And we can also make sure that your GPC signal is being adhered to and being looked at in order for us to be able to make sure that the site is actually in a state where it will be compliant. As far as the long-term solution is to get into, we do it with OneTrust, we can do it with other CMPs as well. We make sure we are configuring your GTM, your CMS properly, and then we run geolocation scans. Those geolocation scans can be triggered from EU, California, Florida, or another GPC state to be able to ensure that your compliance as far as that website is concerned across your top 100 or how many other pages you want us to scan is accurate. And we provide that as an audit report to say we scanned these pages, we found these anomalies, we recommend certain remediations. Your tech team will then work on implementing those remediations. We'll come back and run another scan. That way you have an incremental progress to show to say the first audit report had anomalies, the second one is now clean, or even if the second one has anomalies, it has lesser anomalies, and then we try and make a third pass out of it as well. But that way you have an audit trail to say, here's how we maintained our CMP governance. I think these two get into deeper into your privacy program. Building a data map is critical. We talked a lot about it. Old infrastructure, vendor inventory, what data is being collected, how is it being shared, who is it being shared with, why is it being shared, when is it being shared, what security protocols are around it, how long are you retaining the data. All of these aspects come out of actually building a foundation using your data mapping automation. So data mapping, and some of this can be automated in terms of scans and crawlers, but more importantly, I would say this information has to be done by talking to specific business owners, technology owners, and getting the vendors to participate as well, because it's extremely crucial for you to be able to create that. And as you can see, the last point, that becomes the basis of information governance, because then everybody can tap into that and say, okay, now I know exactly what's happening. It also then bubbles up all the risks that you have. Privacy rights fulfillment, a lot of the litigation that we talked about in the 5 cases earlier had to do with not fulfilling privacy rights properly and not doing it in a timely fashion. So that has to do with having an intake process, whether it's a web form, whether it's taking it through emails. Web form is easier because you can link workflows to it. You can have manual workflows to begin with. Once that process settles down, you can then build APIs to be able to automate that process. So we help organizations, we come in, set up the manual process, and then we work with the technical teams to either build a hub and spoke model for the automatic API-based processing, or if they want, we can call them directly from the particular privacy rights automation system. This way, you have clear responsibilities, you have defined ownership, and you know who has to work on what area depending on the timelines that have been provided as well.
Amazing. Abhi, thank you so much for this presentation. And we have a recording here. We'll be sharing out with people, and well, we'll have a white paper created shortly as well, where you can scan through all this. But if you're dealing with any issues that you think either work for your organization, or you're an agency or developer and it's one of your clients, or someone you know who's been dealing with this, the number of cases are only on the rise. So while people are maybe not getting to this as quickly as they should, and 51% of websites are still not compliant to most of the regulations. As you hear about it and you're looking for someone to help solve it, Solvation. So Abhi, thank you, sir. And
Thank
thank
you
you
very
folks
much,
for
Nick.
joining.
Pleasure. Yeah. Take care. Bye bye.